Diane Klein, and in our session today we will be doing the criminal law section of the MBE, which includes both substantive criminal law and criminal procedure, which can also be thought of in some ways as a subset of constitutional law. It is constitutional criminal procedure will overlap with much of the subjects that are being tested. So there are lots of questions that you will see and correctly analyze as much potentially a question of Fifth or Sixth Amendment constitutional law as they are of criminal law. Right? So criminal procedure is an overlap area in that respect. And of course, the substantive criminal law, many of the situations may closely resemble some of the situations that we encountered in the torts context. So you want to make sure that you're sensitive to those similarities, but also to very important differences when they exist. So just as with the other subjects, there will be about 33 questions in this area. That is, it's one of the 6 subjects, of which, at least according to the editors of our materials, and I think it is accurate to say, at least 5 or so will be on homicide, so we want to make sure that we understand that especially well. This is an area, there are a few others that are like it, where having a lot of exposure to the real law of the area will not necessarily serve you well. There are lots of jurisdictional differences that, of course, are not examined on the MBE because it's a national exam, and then lots of other statutory reforms that have become very common but are not necessarily MBE criminal law. And so you're best served in some ways by not being so much of an expert outside the subject area and kind of focusing your studying and your attention on the MBE, and then of course the potentially essay examined dimensions of the subject as well, which form, again, as we've seen in other subjects, a kind of law of nowhere in particular. But still you want to be familiar with it. It's I think a reasonably coherent whole, even if it isn't actually the law of anywhere. So the first of the topics that's frequently examined and that we want to make sure that we are clear on is the essential element of mens rea, the evil mind or the criminal intent that is associated with pretty much every criminal offense. So criminal offenses can have different kinds of intent, different degrees of specificity in the degree of intent that's required, but because criminal law is intended both to deter and to punish, it's essential in order to find that someone is guilty of a crime that they be in the appropriately wrong state of mind. That things that are done just accidentally can't be deterred by being punished. And so that the criminal penalty situation doesn't work like that. That's different than torts, which can actually have rules that are designed to make people take more care and also to shift losses, right? So in the torts area, we're familiar with the various strict liability torts, which is liability without regard to fault, because what we're doing is shifting the cost of the injurious conduct without necessarily making any claim about anyone's state of mind. Some torts do have state of mind requirements, but others don't because they reflect rules about how to shift the burdens that result from people's negligent or reckless, etc. behavior, which is different than punishing those individuals. Right? Even though one would certainly not want to be on the receiving end of a large tort judgment, the larger purpose it serves is to make people take due care and to shift losses, whereas the primary purpose served by these criminal penalties is both to deter and simply to punish conduct. And we'll see that as we work through offenses that have close tort correlates, just to make sure that we keep those distinct in our mind. When we're considering the criminal state of mind, and this is a slight overgeneralization, but just in thinking about our 2 areas, that is the substantive criminal law on the one hand and criminal procedure on the other, the substantive criminal law is generally going to require us to focus on the criminal's state of mind and the events leading up to and including the crime itself. Whereas the criminal procedure side is often going to kick in at or after the crime. Right? That is, when is the person being interrogated about the crime? Can we search their house looking for evidence of the crime? Do they have a right to counsel when they're being prosecuted for the crime? That is a whole bunch of things that happen at or after, whereas the substantive rules are going to be about the things that happen up to and including the crime itself. So there's a little bit of a timing distinction, and that will just cue you in. If the facts are all about things leading up to the crime, it's much more likely that what you're being asked is a substantive question of criminal law. The slight variation on that has to do with conspiracy and entrapment and so on, where you're going to have a little bit of each. So the first of our subjects here, the first of our more specific subjects, has to do with mistakes of fact. Under the right circumstances, mistakes of fact can be a defense in a way that a mistake of law cannot. That's the distinction. Right? That is, one is subject to the criminal laws of the jurisdiction that one is in. We think of everyone who is in that territorial jurisdiction as being on constructive notice of the criminal law of the jurisdiction. That's one way to think about it, right? To sort of get over perhaps a sense that it would be unfair to convict someone of a crime they didn't know about. The idea is what is criminalized in a particular jurisdiction is available for anyone to find out, and upon entering the territorial jurisdiction of the state, you are on constructive notice of what is criminal there, and hence can, in accordance with our understanding of due process, be prosecuted for violating crimes, even ones that you did not know about. But mistakes of fact are different. That is, in the right circumstances, things you did not know about the facts can be a defense. So we're going to work through some questions that are going to bring that out. So start with question number 1. Start with the call of the question, and then we'll backtrack.
If the jury believes Walter, it should find him.
Right. So a more contemporary way that that question would be phrased, I think, would draw from the facts into the question what it is they're going to be asked to believe him about, because it actually is a little bit confusing. What's at issue here, right? That is, if he is pleading not guilty, are they believing him about that? In which case, of course, they would find him not guilty, right? Or is it going to be something a little more fine-grained, which is what we're going to find out, the thing he actually testifies about. So start at the top. So now the way we would rephrase this question is, if the jury believes Walters was told he had not been convicted of any crime, it should find him guilty or not guilty. Right. If they believe him, that because they have to, in order for this whole thing to get going, we have a piece of his testimony, which is, my attorney told me that in taking the plea is not the equivalent of being convicted of a crime, right? If they believe him that he was told that, right? Not that it was so, because it wasn't so, the attorney's advice is incorrect. If they believe he was told that, do they convict him or do they acquit him?
I believe they convict him.
Why do you think so? But he isn't making a mistake of law. His attorney is making a mistake of law, right? But he's not making a mistake of law. He is making a mistake of fact in reliance on this attorney's advice. But he is not making a mistake of law. Okay?
At the beginning, I said that going into a jurisdiction, you aren't instructed of what the laws are. That's why
Yes. I understand, but that his reliance on his attorney, it would be as if his attorney had told him it's a misdemeanor or it's a felony, right? And he'd relied on that advice. That's not what we mean. That's not the kind of mistake of law that will allow you to be convicted anyway, right? Although I understand it's like a fact about the law, which is a weird thing, right? Because it's not a fact about the world, right? It's a fact about the law, but it's a fact, right? So it's not, I mean, an obvious case, too easy for them to ask a question about it, would be whether it's a defense when they catch you with a pound of marijuana to say, but I didn't know it was illegal here. Clearly, that's not a defense, right? So that's the kind, I mean, in a simplified example, that's the kind of mistake of law, as it were, that is going to do you no good, right? Because it is against the law, and you're on constructive notice that that is so, right? Here, right, I still think it's actually hard to choose between these two answers because I think they're both good answers, right? There's both of the answers that acquit him are pretty good answers, right? Because if his reliance on the attorney's advice wasn't reasonable, then it doesn't seem like he's making a genuine, right? If what the attorney had told him is something no one could reasonably believe, then it seems like it wouldn't count as a mistake of fact, right? That your attorney can't tell you there are 6 days in the week and you rely on it, right? That is, there are things anybody is supposed to know, but this is not exactly one of them, right? So this is a hard question. I mean, D is the right answer, but I think this is a hard question because I think C is also a good answer, right? And sometimes the other right answer is not a very good answer, and it's easy to tell them apart. So this is a question that I regard as pretty difficult. And again, and B is also not a terrible answer, right? Because it's also a true statement, right? So this is a hard question. It's not as if I think there's some magic key to getting this question right. It's a hard question, right? In fact, every answer is a decent answer, right? None of them are just so ridiculously, obviously wrong, right? So, you know, do your best to be able to recognize this situation structurally, because all of these are good answers, right? There's no, like I say, there's no magic key that's going to keep you away from the wrong sort of answer. Well, the statement, like other misrepresentation crimes, right? The statement has to be knowingly false when made. And it was false, but it wasn't knowingly false when made. But again, it does embed the idea that it wasn't just ridiculous to rely on the attorney who told him this, right? Because if it were, right, then we would say, of course you know you were convicted, and your attorney telling you some nonsense is not going to make that go away, right? The other thing that makes this question a little bit hard, I think, in terms of the length and the facts and kind of the setup is he's a witness in a civil trial, etc., and that ends up having nothing to do with anything, right? That is, we've got to get his perjury set up. And so, I mean, you start reading it and you're thinking, this is being used to impeach. Is this going to be an evidence question? What's this all about? So it's hard. This is a hard question. Right? Structurally, I think for a question that's not like incredibly lengthy or rules that are obscure, this is a hard question. Right? You have a lot sort of at the tip of your brain. Correct answer is D. Yeah, but there are easier questions that would draw your attention to the mens rea requirement without implicating a lot of other stuff. So there are a group of specific intent crimes, and whether you try to come up with a mnemonic device to remember them all, or just try to remember, so that you can identify the right sort of intent and circumstances that will not satisfy that, there are different ways to do it. But we want to make sure that we're clear on what the specific intent is that is associated with each of them, and then some other features of the crime, or of the type of crime. So, what is the intent that's associated with solicitation? I will take volunteers so we can get this thing filled in. Well, knowing what? Right, it's the specific intent to have this other person commit the crime. Right? So you've got to have in mind the crime you're intending for them to commit. Attempt? Right. Which may or may not be frustrated by various things, right? I mean, one of the ways that I remember remembering this myself, right, is that you can attempt to kill someone who's already dead, but you can't kill someone who's already dead. That is, you can't be convicted of murdering someone because you shoot a dead body, but you can be convicted of attempting to kill them because every element that needs to be in you is in you, right? The fact that the body you're shooting is already dead isn't going to help you, right? It'll help you not get convicted of murder because you can't kill someone who's already dead, right? But for the attempt, everything will be there.
And then some of these MBEs throw in this reasonable all the time when you're getting in these. And so let's just, there was one where the person fell off a building. Kind of same thing, and shot him. The jury thought it was reasonable that this person already did.
You mean, are we choosing between attempted murder and murder, or attempted murder and nothing at all?
Attempted murder. So was it reasonable to believe that this person
Well, if you reasonably thought what you were going to do was going to kill them, then you've got everything you need for the attempt.
if I fell off this building, I got it, still went over there.
No. Well, no, that's right. If you, right, then I can't. Then I don't think I'm. Well, it depends whether I think I'm killing you or not. See, I can turn out to be wrong, right? So if someone, it's a stuntman and they're filming a movie, but you use it as your excuse to, kill the man your wife is sleeping with or whatever, right? Well, you knew that person jumping off a building was not about to die because he's a stuntman and there's a trampoline down there, whatever. That's different, right, than randomly shooting. I mean, again, we can generate all kinds of kind of crazy examples. But it has to be that from your side, everything necessary for the crime is happening, right? And so an attempt crime will often include a mistake of fact. Right, but it won't stop it from being, the mistake of fact is what will stop the crime from being completed. But that won't leave us with no liability at all because everything that needs to be in you is in you. And so we'll have the attempt crime. That is, you can attempt, another way of kind of thinking about it, and we'll swing back around to this, is you can attempt to do the impossible even if you don't know it's impossible. Right? So you can attempt to kill someone who's already dead. It is impossible to kill someone who's already dead. But if you don't know they're already dead, you can certainly attempt to kill them. And in that sense, you can attempt the impossible. Yes, it's a standby. It's a standby of the TV crime drama, both sides, right? That is, poisoning someone who you think is already dead, but they're not dead, and so you actually do kill them, even though you didn't think you were killing them because you thought they were already dead, whatever it is, etc., right? So again, you just want to keep those separate, right? That what's necessary for the attempt is everything in you, right? But the world may not cooperate in various ways, including the person you shoot in the head who bizarrely survives, right? You can't be convicted of killing someone without killing them, but you certainly can be convicted of attempting to kill. So we usually think of attempt as, in a sense, as incomplete that way, right? You try to kill them, but you fail to kill them and they survive. But that's not the only difference, right, between the attempt and the completed crime. Yeah. Yes. An attempted murder, right. Yeah, it would have to be a crime that has different elements, yes. Conspiracy. What's the attempt? Right, the agreement is an element, right, with the intent to commit the crime. So you can be, again, conspiracy is like attempt in that way, right? Which is that you can have committed the entire crime that is, you can have committed the entire crime of conspiracy without committing the crime you intended to commit. You can complete the conspiracy to commit murder without committing the murder. No, it's the agreement together with the intent to commit the crime you're conspiring to commit. So you can have a completed conspiracy to rob a bank without the bank getting robbed. Right? Because you have the agreement and the substantial act. But none of those acts need to include robbing the bank in order for there to be criminal liability for the conspiracy. Right? In order for there to be criminal liability for robbing the bank, you have to rob the bank. But you don't have to rob the bank in order to be convicted of conspiracy to rob a bank. Just like you don't have to kill somebody to be convicted of a conspiracy to kill somebody. If the conspiracy is interrupted, like the guy who hires a hitman to kill his cheating wife, may have completed the conspiracy, even if the hitman he hires is actually an undercover cop, or it's discovered before he actually carries it out. The conspiracy is complete, even though the crime at which it aims never occurs. I don't think you can be. I don't think you can be. But I'd have to think through, I have to think through whether it's actually possible in the real world. I think you're unlikely to encounter it here. I think you're more likely to be called upon to understand the difference between attempt and conspiracy, right? Which conspiracy requires multiple people and the agreement, etc. Once you have agreement and the act in furtherance, you have the crime of conspiracy, right? And again, that's if you keep the crime something like that you're using kind of as your internal example. If you keep the crime something like robbing the bank, it will be easy to see how the conspiracy, the criminal liability for conspiracy, can arise long before the bank gets robbed, right? And understand how failure to rob the bank will be a defense to the charge of robbing the bank, but it will not be a defense to the charge of conspiracy to rob the bank. And it may not be a defense to the charge of attempting to rob the bank, depending on what foils the plot. First-degree murder. Right, it's the malice aforethought that is relevant to the specific intent dimension. So you can put the whole definition of the crime in here, but the specific intent is the prior intent, the prior planning, the premeditation, right. Criminal assault, that is assault as a crime, not assault as a tort. Right, the intent to commit the battery imminently. Larceny, robbery, they have a similar intent. Their difference lies elsewhere. What is the intent behind both of them? Right, but it's not just a possession, right? It's permanently to deprive the victim of their property. Burglary. Right. And forgery, embezzlement, false pretenses, which I think of as larceny by false pretenses, because false pretenses are not all by themselves a crime. Right, this is the intent to defraud, so it's going to have that material misrepresentation, knowingly false when made kind of requirement. So our next page, page 103, asks us to distinguish between larceny, embezzlement, and false pretenses, or what I usually think of as larceny by false pretenses. So it's like regular larceny, and then there's larceny by false pretenses, and embezzlement. So what's the difference between them? Because they are, of course, similar in many ways. Their outcome is similar. If you get away with it, it's very similar. But the crimes themselves are still a little different from each other. How? Right, so larceny has the taking and carrying away aspect. What's the difference between that kind of larceny and larceny by false pretenses? Well, so the idea is in larceny by false pretenses, you tell them stuff, and so they hand it over to you willingly, right? It's not the same taking and carrying away because they hand it over to you willingly because of the false pretenses. Right, so the outcome is the same. You have it, but they hand it over willingly because you have made these material misrepresentations to them, as a result of which they've turned it over to you. And then embezzlement. Well, it depends. I mean, we don't need to worry about it, I think, so much in that context as to see that embezzlement has both, it has conversion in it, right? So it has the tortious conversion. You have lawful possession, and that's the difference, right? In both larceny and larceny by false pretense. In larceny, you just take and carry away, you never have lawful possession. In larceny by false pretenses, you obtain possession based on the false pretenses. In embezzlement, you have lawful possession, and the crime consists of the conversion. Right? So similar, you just want to tune in particularly to how does the person come into possession? Right? By taking and carrying away, by lying to someone, or by converting property of which they have lawful possession, typically in a context, they're the treasurer of the corporation or whatever it is. Right? So and then there's some kind of counter examples or counter facts.
Just a quick question.
Yep.
If you were, typical thing, clerk that stole somebody's that wouldn't be embezzlement.
It's more embezzlement than any of the rest of these because you're lawfully in possession. I mean, you're an agent of the bailee there, right? So you're sort of committing two different crimes, one against your employer and one against the customer, right? And so again, if we see a situation like that, I think you will not be asked to make fine distinctions. Either they'll be telling you it's burglary when it clearly wasn't burglary, et cetera.
Because, sometimes they try to trick you, whether it's embezzlement or whether it's low-level employee, they're guilty of larceny.
Right, because they're not really in lawful possession, right? I mean, if they're taking money out of the cash register, they are not in lawful possession of that money. But that's different than the person who owns the dry cleaner, who is lawfully in possession of the money, but not to do that with it, right? So yes, and we'll see if we see any that are like that. Do we just want to look at the points in the shaded area, which are little reminders? Yep. Sure. So let me see, the first bullet point, if you intend to return it at the time that you take it, it's not larceny, okay? This has to be a reasonable mistake of fact. Okay. Do his part, right. And that's a trickier one, right? Because he owns the car, but not in such a way as to give him a right to retake possession. Right. But not in a way that gives him the right to take. Right. And then the last one, if the defendant believes the owner of the property owes that property to the defendant, it's not larceny. And again, those have to be subject to reasonable belief up to the point of reasonable mistake of fact, but not beyond. And again, how subtly they're going to examine that, we'll see in our examples and also things that you may have encountered. So now we're going to swing back to page 102 and the mistake of law. And again, what we want is to try to pry apart these mistake of fact, mistake of law situations, which are not always so simple as they seem. So question 2? Yeah, correct. Yeah. Yeah. All right, so we want to be sort of keeping in mind both what it is, right, the taking and carrying away, and the elements that potentially negate it, right, like thought it was yours, intended to return it, right, and then we'll see if they turn out to be easy or hard, that's going to depend on how many good potential answers we have, so start at the top. Well, we know that's not larceny, right? What might it be if it's anything? Not a crime, but a tort? It's conversion, right? The damage beyond repair is a conversion. And if it arises unlawfully, it's even worse for you. But not larceny. Okay? Okay, that's owed. It's owed to him. Right, and again, is it reasonable? Is it unreasonable? We're not given much to go on, right? So it can almost certainly be eliminated, but it would sort of depend on what was coming after. That's the taking and carrying away of an article of personal property. And that kind of mistake is an example of mistake of law. Yeah. Right. And again, when we're told unreasonably, they're making it easier for you, right? Because if it just said mistaking George's car for his own, right? He got into it and drove it home, where the sense you have, first of all, how did he drive it home? But whatever, right? What is this world of cars that can be started with any key? But whatever, right? The idea is, and upon discovering it, he would of course return it. That is, his state of mind is not the criminal state of mind, even if he has made a mistake, right? Once we're told that it's unreasonable, however, right, then it's going to take it outside. So I think without the unreasonable, it would be hard to distinguish, right? But once you're told that the belief is unreasonable, then that's shading over into the criminal state of mind. That's almost not believable. I mean, it's hard what does it mean to say unreasonably mistaking someone's car for, do you believe it's yours, or do you not believe it's yours? It's kind of a weird way to put it, right? Because you would never describe yourself as making an unreasonable mistake. What you would describe is someone else who's claiming to have made a mistake to not have made a mistake and be lying about it, because that is not a mistake anyone could reasonably make, is I think the thought.
Yeah, it comes up on the
It's never right. Yeah.
It comes up a lot. And always confusing.
How does someone make an unreasonable mistake? Right. That's not a mistake, right? That's what they're saying it is. That's not what it actually is. Yeah. And I would almost say, I mean, I'd have to look at more questions, and you can think about this when you encounter them, but I would almost sort of rewrite for myself some unreasonably mistaking as claiming to have unreasonably mistaken the car for his own, right? Because then it's like, and we're not going to believe that claim, and it's not going to work. It's a failed defense. That would confuse you more, then don't do it. Okay. Law of mistake, okay, the flip side on page 104. So this is another way of making a mistake, which is pretty obvious. You just want to make sure that you have the rule clear in your mind. And it's the flip side of mistake in the following way. If you commit a crime that you don't think is a crime, you can still be convicted. If you think what you are doing is criminal, but you are mistaken about that, of course you cannot be convicted, because you can't be convicted of a non-existent crime, no matter what your state of mind, right? That is, it doesn't matter if you think something both is and should be criminal and you feel terrible about it. You can't make a crime out of nothing, right? Only the jurisdiction can make something a crime. If they haven't done so, nothing you do or think can make your conduct criminal. It's not up to you. It's up to the jurisdiction, which is, again, it's not the flip side. It's really two sides of the very same coin, right? If the jurisdiction has criminalized the conduct, you can be convicted of it under the right circumstances. If they haven't, you can't, right? There are no right circumstances. So let's read through the question, but again, the principle is an easy one.
Which of the following situations is the defendant most likely to be not guilty of the charge?
Okay, so now we got to read.
A, police arrested thief and recovered goods he had stolen. The direction of the police. Police took the goods to the defendant. Defendant believed the goods to be stolen and purchased them. Defendant is charged with unreasonably received stolen property.
Can he be convicted? Okay, so part of what makes these questions hard is trying to figure out what side you're on. That is, what are you looking for? What we're looking for is the guy who can't be convicted, right? Defendant most likely to be not guilty. So defendants who can be convicted are answers that we can eliminate. Can this guy be convicted? Yeah, probably. I mean, we need to know more, but it's at the,
These were stolen, and,
he thinks they are.
yeah, he believes, he reasonably believes those were stolen, and
Right, if anything prevents him from being convicted of receiving stolen goods, it won't be, he's done all he can do to try to receive stolen goods, and that's what you need for the attempt crime. So we convict him and eliminate the answer. Right, go on.
defendant misrepresented his identity to secure a loan
Can he be convicted? Yes. Again, he's done all he can do to commit the crime. It doesn't work. The banker isn't taken in, but that's no thanks to our guy, right? Our guy has done everything he can do, and that's what sets you up for the attempt crime. He can be convicted. We eliminate. Right. He buys it on the street, believing that it's illegal to buy this kind of Robitussin Super DM, right? Because there's no crime there, right? You can't attempt to commit a non-crime any more than you can commit a non-crime, right? We would have to read the last answer just to see if it is somehow even worse, right, for the sake of thoroughness with this kind of question, but C looks like our candidate. Correct, because he's done everything he can do to murder her. It's just that life has intervened, right? All right, so those are pretty easy. The only thing that makes them complicated is what you alluded to, losing track of what side we're on and what we're looking for. So you just want to be careful whether that means you note it on the side, looking for the, who can be convicted or who should be acquitted or who isn't. I mean, you can rewrite the question and make a note to yourself so that in the process of reading the answers, you don't lose track of what you're looking for and lose valuable time. Because the question is not hard. The question is potentially a time waster as you're trying to figure out, I'm sorry, who was I supposed to be looking for? The guy who can be convicted? The guy who can't be convicted? I don't remember.
So that's the hardest part.
At times, sure.
Is that I can waste so much time just like something like that. Where what can I just read?
Right. Whose side am I on?
Just read
Yes.
those.
Yes, which you don't have. Right. So that's, read with care and freely mark things up, rewrite it, write something next to it, that will help you keep on track when you're going to have to read through some answers that are longish. The other thing that is that now answers will be closer in length to each other than these are. This is, when the right answer is the suspiciously longer answer, yeah, that's mostly been taken out of the test, so for better or worse. Don't waste too much time like that. And you can also, again, since we're now kind of getting down to the wire, as you are doing these, I hope you are doing them in exam-like conditions and exam-like quantities, if possible. Not necessarily 100 at a time, because that takes a long time. It takes a long time to go through and score them for yourself, and you've halfway forgotten them, right? That is once you're like, I missed number 7. What was number 7? But doing 25 or 40 or 50 in that range, an hour's worth, trying to do 33 in an hour, doing as many as you can do in an hour and seeing how many that is. These are useful exercises for sure, and doing them at exam times to the extent that you can, right? That is within the exam block of time, doing as many as you can do in an hour, as many as you can do in 90 minutes, right? Something like that I think is a useful thing to do. And note the ones where you feel less than 100% sure. See if you have time to swing back. Begin to get a sense of whether you will easily get through 100 in an hour or 103 hours, or you just won't, in which case, it's kind of a wing and a prayer whether you're going to have a chance to get back to it. You might, but don't get too hung up on it. You're likelier to have time to get back to it if with those ones where you just have to, at a certain point, leap, you circle the question number, planning to come back, it may all work out. And it may be that when you do that and you circle back, it will jump out at you, either that you were right or the way that you were wrong, right? And if you know why you're not sure, you can write that next to the question too, right? That is, you can actually write, I mean, and this is, when we think about strategy for the MBE as a whole, it may be that later questions will contain correct statements of a rule you have sort of forgotten. And if you've noted to yourself, does larceny, or whatever it might be, it may be that something that comes later will remind you, and then when you go back to question 12, you'll have been reminded. The more of it you can hold before your mind simultaneously, the likelier that will be. Because again, as we've seen lots of these, oftentimes an answer that is a wrong answer to a particular question is nevertheless a correct statement of the law. And that test is going to include many, many correct statements of the law that can help you a lot if you're attuned to them, even though they won't be the right answer for that particular question, right? So that these are sort of larger scale strategy issues just to be aware of. Page 105 and is a reminder for some more of these specific attempt crimes, receiving stolen property and attempt. So what are the elements of receiving stolen property, or the definition of receiving stolen property? Anybody? Not attempting. You're not receiving stolen property until you're receiving it. Right, so you have to have both possession and control of the property, known to have been obtained as part of a crime that included the intent to permanently deprive the owner. Yes, so receiving or taking possession and control of stolen property, so it has to really be stolen property, known by the receiver to have been obtained as part of a crime that included the intent to permanently deprive the owner of their interest in it. So it both has to actually have been stolen, and you have to believe that the person who gave it to you came into it as part of a crime that involved the permanent intent to deprive the owner of their interest in it. Otherwise, it's not stolen property in the relevant sense. That's right, and you can be guilty of attempt, but not of the actual crime. The most they can get you for is the attempt to receive stolen property, because the property is not actually stolen. And then an attempt, we've touched on this already a few different times. So one way to define it is the criminal act that, if successful, would be the crime. Attempt requires the same specific intent as the crime of which it is an attempt. So the attempt to commit murder requires the same intent as murder. And again, I think it's most usefully understood or remembered as you've done everything you can do, right? The reason the crime does not succeed is not because of anything different about you. It's something about the world, right? So you attempt to receive the stolen property. Turns out, wasn't stolen. But that's no thanks to you, right? You thought it was stolen. You did everything. You had the mens rea associated with receiving stolen property, but turns out not to be stolen. Try to kill the person. Turns out to already be dead, etc. And the only exception to that, although of course it's not really an exception, is your mistake of law about its illegality, right? So you can't attempt to commit a crime that, if successful, wouldn't be a crime because the conduct is itself not, in fact, criminal, though you believe otherwise. That's our attempt to buy the legal cough syrup. So now we're going to talk a little bit about some defenses. So page 106 the defense, or the limits on the defense, we see in our shaded portion. Voluntary intoxication, any kind, is only a defense if it negates the requisite intent of a specific intent crime. So it can be a defense, but you have to look closely to see whether it negates the specific intent associated with the crime for which it is being offered as a defense. So, number 4. All right, so this is another one. We want to keep track of what we are looking for. What we are looking for is the acquittal. All right, so who gets acquitted? That's the question. Who gets acquitted? And you can write that in the column next to it so that as you're reading through these, you're keeping in mind, are we acquitting the guy or convicting the guy? Who gets acquitted? Okay? Convicted, acquitted. Right, because this only makes it worse. Right, this is someone whose intoxication makes it worse. What were you doing driving so drunk you could not see a car, couldn't tell a car, a parked car from a driving car or whatever? Okay, go on. What's the crime he's being charged with? Right. Did he have intent to kill Watts or anybody else? No. So he can probably be acquitted of that crime. There might be a better answer, right? But here, whether it's because, I mean, he isn't even really using his intoxication. He's really using his lack of knowledge. It wouldn't matter why he didn't know, right? He said, you can't convict me of assaulting someone with the intent to kill them when I didn't even know they were there. Right? And he's right about that, whatever the reason is. Now, if they were in a small room that was well lit, that's going to be a hard case to make. But if they're in a forest, they're in a parking lot in the middle of the night, and what, etc. Okay, go on. Does a gun have to be loaded for you to be convicted of armed robbery? No, so not even relevant to the intent, right? So again, helps if you know that little fact about armed robbery, but even if you don't, right, that's not the crucial thing. It's not that he's saying, I didn't know I was robbing anybody, I didn't know that I was putting anybody in reasonable apprehension that I was going to do it, right? That's not what he's saying. I was in a fugue state, right? He's just saying, I didn't know whether the gun was loaded. Okay, go on. Because it's right, it's not a specific intent crime like that, right? That is, he doesn't have to know how old she is, it's statutory rape. So there is a mens rea requirement, but there's no knowledge requirement about the age of the person. You have to know what you're doing, but you don't have to be intending to have sex with an underage person to be convicted of having sex with an underage person. Right. All right. So that one ends up being not so hard, right, because of what our other answer choices are. Correct, because you don't have to know that what you're doing is having sex with an underage person. Imagine that a woman, imagine that a woman is drunk and an adult woman is drunk, passed out, right? And an underage boy has sex with her. Is she guilty of statutory rape? She is not, right? Because she wasn't intending anything at all. She wasn't even conscious, right? She didn't intend anything at all. That's different than intending to have sex with someone without knowing it's an underage person. You have to be intending to be doing what you're doing under one description, although not under another description. Okay. All right. Okay. Page 107 kind of is another variant in a way on killing the person who's already dead kind of situation, right? Which is about causation, whether the defendant's conduct is the cause in fact, although I think I would phrase it a little bit differently than the editors of our materials do, because it's a little bit weird to say, as we say here, if his actions were not the cause in fact of the crime, then the defendant is not guilty of the crime, but he might still be guilty of attempt. It may be that there is no crime, right? The example that we're about to see is one in which we have an attempt crime, but not the underlying crime, as we'll see in a moment. So it's not a question of whether the defendant's conduct is the cause in fact of the crime. The question is whether the defendant's conduct is the cause in fact of the outcome, which may or may not be the result of a crime, right? All kinds of bad things can happen, right? Someone falls off a bridge, you shoot them, right? If you're not guilty of murdering them, no one is guilty of murdering them. There may not be a murder here, even though there's a death, right? The question is, are you the cause in fact of the death, not are you the cause in fact of the murder? That would be a weird way to put it. You don't cause crimes, you cause the outcome, right? And that's the judgment of the jurisdiction is some ways of causing some outcomes are crimes. Other ways of causing those outcomes are not crimes. But the outcome is the outcome, right? Accidentally knocking someone off a bridge to their death is not a crime if it's not a crime. Pushing someone off a bridge to their death is a crime. So the question isn't did you cause the crime? The question is, did you cause the death in the way that this jurisdiction regards as a crime? So again, it may seem like a fine point, but we just want to be aware that sometimes the question is not did X or Y commit the crime, but is there a crime here at all, right? Did X cause the outcome, right, that would be associated with the crime of which X is being accused? So number 5? Yeah, go to the question. Yeah. Okay, so give us both of those sentences. Right, so if that was all in one sentence, it would be, should the father be convicted of murder defined in this jurisdiction as this? Yes, no, yes, because, no, because, no, because. Okay? So we take it from the top. Yeah, it's a horrible story, and it's hard not to be distracted sort of by the horribleness of the crime described, and I have no real advice about that other than that you have to kind of harden your heart while you're reading these questions. What else can we say? Some of the circumstances described will be terrible. If there are going to be questions about crimes, what can we do, right? So, is this a murder? Right. Right. And so, right, so which is the better reason? Right. And let's see, how's that superior to the other answer on that side? Right, and we know that wouldn't result in his acquittal without the essential fact. Right? The question is, did his actions cause the death? right? Not what did he believe about it, right? Because that would be more like mistake of law. I'm allowed to do this, even if it has this outcome, right? That's different. And we can imagine, let us say, a more benign case, just because it's less horrible, maybe, like a vaccination case, right? Someone who doesn't get their child vaccinated, and as a result, the child contracts an illness, right, and dies from it. That's not a murder. It might be reckless, but it's not a murder, right? It's not conduct that was undertaken with the intent that it kill the person, even if it does actually result in the death of the person. That's not a murder. Right? It's not a murder to prevent your child from being vaccinated, even if we think it's criminal negligence, it's blah, 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 right? But it's not a murder. Right. Right. All right. Yes. Now, starting on page 108, we turn our attention to accomplice liability. We were talking about some other questions that are in this area that can be difficult. And I would rephrase or a little bit expand on the rule about accomplice liability here. Although our headline is a good one and useful. If someone else did it and you encouraged it, you're an accomplice. Say, although it's not enough to make you an accomplice simply to wish someone dead, it is enough if you wish someone dead and you actively encourage another to do the deed, right? So accomplice liability has both a subjective and an objective component, like every crime, right? It has a mens rea requirement and it has an act requirement, but the act is encouraging somebody else. And there's a mens rea requirement. Right? There's no accomplice liability for someone who has no idea that what they are doing is somehow having the effect of encouraging someone else to commit a crime. And you can see this sort of the dicier examples of this, but that are also like the tabloid examples, right? The woman who complains to her lover, oh, I wish my husband would just disappear. Is she actually intending for her lover to go kill the guy? He insists that she is, that that's what she meant when she made that veiled statement. She vehemently denies it. That's going to be our question for the jury, right? In saying, I really wish my husband would just disappear. Was she really encouraging someone to murder him? Or was she not in the least encouraging someone to murder him, right? These words may be susceptible to multiple interpretations, but her accomplice liability will depend on how those words are understood. Right? What is her do they really reveal a state of mind that wishes his murder? Is this really the active encouragement of someone to murder? Or is it an idle speculation that has no such meaning? All right, we have two different questions coming out of this, and so one of the things that we want to be reminded of in these kinds of questions, even if you only had one of these questions, is pay attention to which defendant you're being asked about and follow their behavior and no one else's, whether that means you like highlight, circle, draw an arrow, whatever, so that your focus in answering the question is on the behavior of the defendant you are being asked about. Okay? So number 6, that's the question.
Number 6, on a charge of murdering Vic, Sam.
All right, so now we're going to read the facts looking for Sam only. All right, so we're going to read all of them, but our attention is on Sam. Okay, go ahead.
Bill and Chuck hated Vic, agreed to start a fight, and the opportunity arose to kill him. Bill and Chuck met Vic in the street outside a bar and began to push him around. Raised Sam who also hated Vic, stopped to watch. Ray threw Bill a knife. Sam told Bill, kill him. Sam told Bill.
Right, so you could highlight that, draw an arrow to question 6 or something like that.
Tom, who made no move and said nothing, proved that Bill would kill Vic with a knife. Chuck held Vic while Bill jabbed and killed him.
All right, so all we have is this statement, right? Ray threw Bill a knife. Sam told Bill, kill him. They are on the scene. Is this enough for accomplice liability? Right, and we know they hated him, right? So we'll have to see how fine-grained our answers are, right? Because we have evidence of the thing he did, right? That's the encouragement. Our evidence of his state of mind is not quite as good. No. Ray threw Bill a knife. Sam told Bill, kill him. Correct? And said, kill him. But he didn't. But that's the question, is whether we're going to have an answer that really goes to that state of mind component or not. Because we do have his overt act. Seeing the knife in the hand of the guy, he says, kill him, right? But we don't know as much as we might want to know about his state of mind, right? Because how would he defend himself? He would defend himself by saying, oh, I didn't really believe he would kill him, or whatever, right? Because what he said, we have evidence for. All right, so now let's look at our answers. Well, is this a correct statement of the law?
Yeah.
Mere presence and oral encouragement, whether or not he has the requisite intent, will not make him guilty?
Or whether or not, no.
Right, so this is a false statement of the law, right? So that one we can eliminate that way. If you read it with care, you realize that's a false statement of the law, which also actually has the value of reminding you of the right statement of the law if you can recognize that this is a mistake, right? Because then you say, no, right? Presence and oral encouragement with the requisite intent will make him guilty. Intent is never irrelevant. It's a crime. Accomplice liability is criminal liability. Go on.
Guilty because of the intent that Bill killed him, which I encourage.
Right? So it's a good answer, right? It imputes an intent to him that's less than completely clear, but at least it has both that subjective and objective component. And our other answer?
Guilty because he aided and abetted.
No, because then where is our act? That's subjective, but no objective component. Merely being present is not enough, right? So you can see, even reading through those answers, it's like you get the whole law of accomplice liability. If you can recognize, right, if you can recognize the parts that are right and the parts that are wrong, you're given like a little recap of accomplice liability, even as you are being reminded that he's guilty of it here. Okay? And now do our next question, because it comes from the same facts.
When a charge of murdering Vic, Tom is.
Okay, so what did Tom do? Right, but hoped. All right, so guilty or not guilty? Because roughly, don't look. Generate the answer yourself. Right, we've got no objective act, no overt act. We're looking for an answer like that. What do our answers say?
A, not guilty because mere presence coupled with silence equals suspicion.
Okay.
Not guilty because it's not felt ill ahead of time, but it's
Right, A is a good answer, right? It's what we were looking for. You would just check the other answer to make sure it isn't better in some way, and it's worse because that's not what you need. You still need that overt act, right? Okay. Let's look at C and D just so we have them for the sake of completeness.
C, guilty because he had a duty to stop the killing and gave no attempt to do so.
False statement of the law, right?
D, guilty because he was present and proved so.
Takes more than that, right? So that's that reminder, you need both that subjective and objective component, right? And that's, you should be so lucky as to have your accomplice liability questions be as easy as this, right? But the crucial thing in terms of managing time well is paying attention to which defendant you're being asked about, because we've also got Ray in here and no question about him, right? And so we've got a crowd scene going on, right? And lots of different questions could be asked about this. Is it a conspiracy? Who did it, right? Chuck held him, Bill stabbed him, etc. But none of that's relevant. Look at your questions to see which defendant we're being asked about, right? And then it's easy, right? It sort of jumps out. You've got one little sentence and that's all you need. Yep.
So on number 10,
Well, there's no abetting. There's no abetting. We don't have an overt act. Just being there is not, it kind of relates to this, no good Samaritan, and relates to the wrongness of answer C in number 7, We might think people ought to have a duty to stop murders, but they don't, not as a matter of tort liability, and they don't as a matter of criminal liability either. You can just stand there, and that does not make you an accomplice. It may make you a bad person, but it does not make you an accomplice from a criminal point of view. All right, so conspiracy on page 109. Right, the agreement and the overt act in furtherance. That's what you need. So you have a meeting of the minds, kind of like contract concept, meeting of the minds, plus overt act. So you need more than the meeting of the minds, more than the agreement, which can be idle, right? And the overt act. But the overt act doesn't have to be, first of all, the overt act does not have to be criminal in itself. Right? So you can legally buy your bomb supplies together with your agreement to bomb the bank, right? The overt act does not have to be criminal in itself. And there have to be two guilty minds. So no conspiracy between one law enforcement person and one criminal. That's not a conspiracy. There have to be two guilty minds. Attempt, maybe, but conspiracy, no, when we have one law enforcement person and one criminal. Criminal could be attempting, but not conspiring with someone who's a law enforcement official.
Would an overt act be as small as it's reading the law
Yeah, if you wouldn't be doing it otherwise. If you wouldn't be doing it otherwise. It has to be pretty clear that it is an overt act in furtherance.
that would be sufficient?
Yes, if it's an overt act in furtherance, it does not have to be a large act. That's correct. Okay. Also, conspiracy does not merge with the underlying crime, unlike attempt. Right? You don't get charged successfully with both murder and attempted murder. Every successful murder includes a successful attempt at murder. Conspiracy is a separate crime. And the same with solicitation, right? Solicitation merges, conspiracy does not. So attempt and solicitation merge, conspiracy does not. They are lesser included offenses, conspiracy is a separate offense. Okay. All right, on page 110, and I think here I would change the headline a little bit, or just don't get distracted by the headline. An apology simply won't do, which is of course true, right? But what we're really paying attention to is the change of heart, right? And the change of heart after the crime is complete comes too late. So that's what you have to be looking for, is when does the change of heart come? And the act in furtherance, right? So even if you never rob the bank, it doesn't mean, right, you can't be convicted of conspiracy. Well, you have to be paying attention to which crime, right? Once the crime is complete, the subsequent change of heart will not change things. But we've got to be paying attention to what crime it is as to whether it's complete, right? Because you can start to attempt to do something and have a change of heart, and then it's not a murder, and it may or may not be an attempted murder. Because remember, for the attempted murder, everything you have to be done from your point of view, right? And so even you may not even reach the attempt stage if there's more to be done by you, right? Acquiring all the elements for the poison you're going to use to poison somebody, but you never combine them, you never make the poison, and you never go through with it. That's not even an attempt. Right? Not only is it not a murder, that's not even an attempted murder, because there was more to do for you, right? So again, you want to be paying attention to what is the crime, so that you know whether the crime is complete before the change of heart, the apology, the remorse, whatever it is. All right, number 8. Right. So the question would be, now, is Damson guilty of burglary or larceny? And then yes of both, yes of one, not of the other, not of each. So you can see that A is yes to both, right? B is yes to burglary and attempted larceny. C is guilty of burglary but not guilty of any larceny offense. D is not guilty of anything. All right, so it's sort of A and B, A but not B, B but not A, neither A nor B. It's not quite that logical structure, but it's close. now that would be in the question, so you would know what you're looking for are burglary and or larceny, right? What's the important difference between the two of them? You've got the breaking and entering for the burglary side, okay? All right. All right, what is the status of things right now? And? Yes, right? Both of them are complete, right? He's broken, he's entered, he's taken away with intent to permanently deprive on the front lawn. Both crimes are complete, right? Nothing that happens later other than certain kinds of mistake of fact could change that, like turns out to be his own house, right? Something like that, right? But other than that, assuming everything we've been told up to now is true and there's no hidden mistake of fact, nothing that happens later can change it. Okay, go on. Right, yeah. This change of heart comes too late. Yes, because the crime was complete at the taking and carrying off with the intent to permanently deprive. He had that intent when he did it, right? The mens rea and the objective act came together, right? And the fact that something happens later on the front lawn, not to the point. Okay? And we have our definition of burglary already. Page 112. A reminder to keep your eye on the defendant. Don't let your focus wander away from what the defendant does. The MBE may try to trip you up by making the victim particularly worthy of the offense. That is, he had it coming. Remember, if all the elements of the crime have been met, neither the victim's consent nor the victim's own negligence can negate culpability. This is a little different than in the tort circumstance. All right, question 9 is long, and it's going to require some analysis to handle a question like this because it is so long and potentially so time-consuming to answer. Right? So you definitely want to be jumping ahead to the bottom so you know what you're even looking for because it's so long.
Defendant is charged with murder. Which of the following is
All right, so this is he going to be convicted or acquitted of murder? Right? So it's with that in mind that we're then going to read this long question that we'll see has a particular structure. So start at the top.
the homicide statute in this jurisdiction reason for assault? Murder is a lawful killing of a human being with malice aforethought.
All right, so that's what we're going to be looking for. There's going to be other variations and details and whatever, but that's what we're going to be looking for because the question is, can he be convicted of murder? Right? And he can't be convicted of murder unless it's going to satisfy this definition, which is now going to be expanded on, right? But that first line, that's the same sort of definition of the crime. We've encountered it elsewhere that you want to have more or less memorized. Go on.
Such malice may be expressed or implied. It is expressed when there is a manifest and deliberate intention of the take away the life of another person. It is implied that it is considered a provocation or circumstance. Only that it shows abandonment and willingness to fight. Every person guilty of this
Blah, blah, blah. We know that part is not going to be relevant. You actually can strike it out so that if you find yourself having to go back and read this definition, which you very well may, you won't be distracted by that. This question is not about the penalty that's going to be imposed. They've thrown that in there just to make the statute sound more real and complete, but it's not relevant, right? What's potentially relevant is going to be whether we're going to be able to find malice. It's not, I mean, just as a strategic matter, it's not going to be overtly expressed, or they're not going to be giving you these facts that go on and on. It's that there's going to be, I would cross out that last sentence because it's irrelevant, and forcing yourself to read it again is just a waste of time. Right? The rest is relevant because we have what counts as malice expressed, malice can be implied, So chances are, right, this is going to be an implied malice. The borderline is going to be between malice implied by circumstances, etc., or not to be implied by the circumstances. Yep.
Because they gave us both definitions, that the question's really going to be on
Telling that,
trust between those two.
correct. Okay?
Manslaughter is again lawful killing.
Right, so this is going to be a question about malice, right? One of them has it, one of them doesn't have it. We're going to be looking in our facts for malice. Okay? Yeah. Blah, blah, blah. Who cares? Cross it out. Yes, it's handy, right? But there's a lot of law in there, and it's correct and useful, and could potentially be useful for some later question about involuntary manslaughter when you've halfway forgotten what involuntary manslaughter is. This can come in very handy, but you don't want to be distracted by it here, right? So here, what we're looking for is satisfying the malice element, right? Because murder has it, and it can be implied. Manslaughter doesn't. That's going to be our situation. So now let's read our facts with that in view. Right, and this stuff, I mean, obviously those are facts that are not legally, they're legally relevant for what they don't say, right? That is, what they're doing is taking away the quarrel, the heat of passion, right? They're setting the scene, right, in a particular way. It's not as if, does it matter that it's a teenage hangout? Does it matter that it's not a pizza place? Of course not. Right, what we're getting is a sense of the relationship between them, right? They're not people they're not fighting neighbors, they're not, right, etc. Okay, go on. Yeah, okay. Yeah. Right, and now they're going to tell you what Russian roulette is. Okay, we don't need to belabor what Russian roulette is for the. I mean, it's bizarre the things that the MBE writers think everyone knows and think people don't know, and so we've got a whole paragraph here on what Russian roulette is. Isn't it enough to know they're playing with a gun and someone's going to get shot? Do the odds matter here? Right. All right, go on. Right. I mean, this is important. This would only be important if another question is coming down the line about the liability of the father, right? Which is not what our question is going to be. We don't think. We don't know. I mean, we're told victor and defendant, so we already know, right? We know who's going to do the killing here and who's going to get killed. So this stuff about the father would only be relevant if we had a question coming down the line about him, which we don't. Okay, go on. All right, so that's an issue that you're supposed to know. Is that going to affect the potential criminal liability of the guy who shoots him in the head? His agreement?
Well, his agreement to play Russian roulette.
It negates nothing. Right, you can't consent to have a crime committed against you. It doesn't work like that. So that's don't be fooled. Right? Don't be fooled that they are together engaging in this very reckless activity. Nothing you can do can give someone the right to shoot you in the head. Nothing. Okay? There are things you can do to provoke them into doing it. That's different, right, than saying, let's play this crazily dangerous game. No. Okay? Right. We knew that was coming. In Act 1, we knew that gun was about to go off. Right. All right. So, all of that just comes down to, is there enough malice here for murder? That's the entire question, right? Is there enough malice here for murder? It's not going to be express. There's no deliberate intention unlawfully to take anyone's life, right? It is implied when no considerable provocation appears, which this is not a provocation case, or when circumstances attending the killing show an abandoned and malignant heart, which for all its colorfulness, is that this situation? Yes, and so he's guilty of murder. I mean, that's it. CD, right, is just, is he guilty or not guilty? And notice, we are helped because A and B are not very good answers, right? So A,
A is not guilty because consent
not to murder, right? They're right, not to murder. And B, not to murder, right? Not to criminal liability on the part of someone who took a gun and shot somebody in the head, right? Well, that's the whole question, right? The whole question is it C or is it D? Because A and B are so terrible, right? And so the only issue is whether this is the sort of thing that will show the abandoned and malignant heart. And a game that has the death of someone by shooting in the head is different than even many other games from which death might potentially result, right?
from a strategy standpoint.
Right.
We basically
Right, but we don't know, are they children? Are they, I mean, there's no getting through it much. I mean, you can skim a lot of it, but unfortunately, I think you really cannot skip a lot of it.
I bring this up only because the model is
Right,
and that the C was just so spot on guilty of murder. I mean,
right.
We're talking about somebody
Well, it's only D, right? Right, but there are circumstances under which that could be involuntary manslaughter. For example, he is showing his friend his father's gun and it goes off. That's not a murder.
Why not?
You have to well, but I mean, again, you're reading the story and having, right. I mean, so once you're in the story, then you've got to know whether there are other mitigating factors. Not while playing Russian roulette, correct. Right. Okay? But yeah, that's just, is it murder or is it manslaughter? Right. Okay. Number 10. Okay, so this is going to be about a robbery. We don't know who's doing what, so you just sort of want to have those elements in mind, right? What is a robbery? Right, force or fear, right? Okay, so that's what we're looking for. Start at the top. All right, so we're like all over the place in terms of the questions that could possibly be emerging from this, right? We've got a question about the search, about who the evidence can be used against, about a conspiracy, about an attempt crime, about the liability of Jack, about the liability of Paul, who appears to be the panicky getaway driver, right? We're all over the place, right? So let's take a look at what is his best defense? All right, is that a defense? Why not? Right, if they'd completed the crime, they would both be guilty of the crime. Right, and we don't know that it really was, I mean, we're told the story in a particular order, but, right. Right. then there's no robbery, right? So there are some hard questions that could come out of these facts, but that's not one of them, right? So be thankful that you're not asked about who the evidence can be used against and et cetera.
So the answer critical
Mm-hmm.
the reason was
Because then it's not a robbery. Right. Well, again, maybe they should have, shouldn't have, whatever, but if they weren't, if the person was not actually afraid, then the person was not actually robbed. Right? Yes, I guess we would put it that way, right? Because do we think that that teller thought he had to give him $1? No. Right, and so no force, right, no fear, no robbery. Right. So again, that's our reminder, whether we do those in the other order, right? I would say we can put page 115 before page 114, so we're reminded of what a robbery is, the threat of injury, the fear, the force, etc. Okay. Page 116, it's a little more, take us through kind of the logic of homicide. So again, we might want to do that, you know, even before the Russian roulette type question. It might have been useful to do this, although we also have the homicide statute. So we'll start at the top just to fill in our blank boxes so that we understand the logic. So, did the defendant actually cause the victim's death? If not, no homicide, though possibly attempt and possibly conspiracy also. Right? Because the conspiracy could be complete even without any murder happening. And that's also our child killer. Right? Didn't actually cause the victim's death, no homicide. Other crimes maybe, but no homicide. But let's say yes, they did. Then we go down to our next box. Did the victim's death take place during the commission of a crime? If so, we ask if it was an enumerated felony. And if it was, that's the felony murder situation. Right, so what are those felonies? Rape. Yes. Mayhem. Yes. Okay. If it wasn't one of those, then what is it instead of felony murder? Felony murder's, you know, pesky little brother, misdemeanor manslaughter. Yes. So it's still a crime. Maybe misdemeanor manslaughter. And one of the common predicate offenses for that is grand theft auto, which people think is a serious crime and so can kind of be tricked into thinking that that's a felony murder situation. Because it's a felony, but it's not an enumerated felony for these purposes. And so the grand theft auto may be a felony, but the death will be a misdemeanor manslaughter. Yes, it has to be an enumerated felony. That's the trick. It's not a death that occurs during the commission of any felony. It has to be an enumerated felony.
So someone died during the
If they just die as opposed to getting shot in the head, which is a regular old homicide. Accidentally, right? They jump out of the car and you hit them by accident while stealing their car. Right? That is not a felony murder. They make them have a heart attack. That's even less. That's even less because then it's it may not even be a voluntary manslaughter. But sticking them up and placing them deliberately in fear, then their heart attack may be a foreseeable consequence. Whereas saying, get out of your car, I'm going to steal it, I'm not sure that has as a foreseeable consequence, that someone will have a heart attack and collapse on the spot. That's for torts, not for crime. So no, it didn't happen during the commission of a crime, which is really kind of a detour, right? Felony murder is kind of a detour. I would actually put these in the other order, right? Take us through the intent crime, and then because the felony murder is always in the absence of the intent to kill, right? Because if there was intent to kill, you wouldn't need the felony murder rule. You'd be using the regular murder, right? It would be a regular murder. But in any case, did the defendant intend to kill or inflict serious bodily harm, or did the defendant act in reckless disregard of human life? I would also be inclined to break those. It's not helpful to have compound questions in this kind of structure because they can always be answered yes in two different ways. and no in two different ways. But yes, they did one or the other of these things, right? Intended to kill or inflict serious bodily harm or acted in reckless disregard of human life. Yes. Was the defendant acting in response to adequate provocation? If so, then it may be a voluntary manslaughter at worst. At worst, it may be even less. But if not, then it's a murder. Right? Intended to kill or inflict serious bodily harm, and it was the actual cause of death. We know that from the top. It's a murder. But even without that intent, did the defendant act with criminal negligence? If so, it may be an involuntary manslaughter. But if not, no homicide liability and no attempt liability. So there are different ways to create this kind of a chart that will give you the logic of the situation, and will have as its outputs, which are the rectangular boxes, what the person is liable for, if anything. And if those kinds of charts work well for you, I recommend that you create them for other complex sets of offenses. You could do it with robbery, larceny. I mean, you could do the robbery, larceny, the embezzlement by false pretenses, any of those, right, where you have this yes-no question structure, right? Was there an intent to permanently deprive? Yes. Was there also misrepresentation? If no, it might be this kind. If yes, it might be that kind. So if these kinds of things work for you, if they're easier to remember than lists, then I certainly encourage you to make them. Like many such things, making them is really what puts it into your head. It's not the time you later spend looking at it. It's what goes on internally in thinking it out in such a way as to make the picture. Then by the end of that, you know it. You just know it, right? You're not relying on the picture or the chart. All right, so with those concepts and that logic before the mind, let us turn to question 11 on page 117. Where are we? Here, okay. Okay, so what are we looking for just at a glance? Right, and actual cause, right? They've got to actually cause the person's death and want to and mean it and whatever, right? So that's an easy way to structure the question, right? Keeping in mind that we also have felony murder floating around, right? So common law murder is like regular full-scale homicide and then felony murder, keeping in mind the enumerated felonies requirement. All right, so we'll start at the top. Murder? No, because, right, and heat of passion, it's a quarrel, that's not murder, okay? Is this a felony murder? Yep, that's an enumerated felony. Yep. Okay, so that you could write felony murder next to it and then see if you've got a better murderer coming along. Right. Right, not a felony and no intent to kill. Right? Right. No intent to kill anybody, not an enumerated felony, so we end up at B. So if we had a real common law murder, that would be better, right, than the felony murder. But felony murder is a common law form of murder, and that's good enough if that's the best we've got, right? All of the others are clearly not murders at all. They are killings, they are not murders. B is a murder, so it's our best one. So again, just like the others, when's he least likely, whatever, what you're looking for is who's the murderer? That's the question. And 3 of these guys are not murderers. They're killers, but they're not murderers. All right. A little bit of the rules of self-defense. Start on page 118. The rule is you can use non-deadly force when you reasonably believe force is about to be used against you. You can use deadly force when you reasonably believe that deadly force is about to be used against you. So that's the thing you're looking for, right? The reaction versus the overreaction, how much force is being used, how much force does the person believe is about to be used against them. Right? That's the guideline, okay? Right. All right, so we're looking to see whether we have a murderer here or not. So we'll start at the top.
Ted frequently visited Janet, his next door neighbor. Janet was separated from her husband, Howard. Howard resided with his mother, returned from the house in which Janet resided. Late one night, Ted and Janet were sitting on the bed in Janet's bedroom drinking when Howard burst through the door and told Ted, "Get out." When Ted refused, Howard challenged him to go outside and fight him. Ted again refused. Howard then pulled a knife from his pocket and lunged at Ted. Ted grabbed a lamp, struck Howard on the head, and killed him. Ted is charged with murder.
All right, is Ted a murderer? He is not a murderer. He's a killer, but he's not a murderer. Why not? Right, we don't have the premeditation to begin with, right? And is the response appropriately in sync with the force used against him? Right, we got a knife, we got a lamp, right? So a lamp is not an overreaction to a knife, right? So now we'll see which is the best of our answers. Start at the top.
A is not guilty because Ted had as much right as Howard now.
Right. Irrelevant.
B, not guilty because Howard attacked Ted with a deadly weapon.
Right, that's our better answer. We'll read through all of them, but that's an easy one, right? Because the other not guilty answer is not a very good answer, right? And so we can think of other answers that might get at it come at it from another direction, right? For example, if it said not guilty because Ted did not intend to kill him. Better answer, worse answer, right? It seems to me that's as good. That would be hard to choose between, right? He uses deadly force in response to deadly force and doesn't intend to kill him. How could he's not a murderer? Those would be hard answers, right? And you also want to be aware that's another direction of a right answer, right? That he just never had the intent to kill him. It's not clear there's nothing here that suggests he had the intent to kill him as opposed to disable him, right? He grabs for the lamp to try to keep himself from being knifed, not to try to kill anybody, right? And so to me, he's not a murderer, period. He just doesn't come close to having the right intent. We don't have to get to that next level of was he provoked, was he in self-defense, was he using deadly force to respond to deadly force. He didn't even intend that it be deadly force. He didn't take out a gun and shoot him, right? He grabbed for a lamp. Did he even believe it would kill him? Right, so there are different things that might be a right answer here. This makes it easy because the right one is a good answer and the other one that comes out on the right side is a bad answer, right? And our wrong answers?
C, guilty because Ted's presence in Janet's bedroom
No.
D, guilty because Ted's failure to obey Howard's forced to leave the house.
Irrelevant, not what the question is about. All right, so that's the end of the substantive criminal law material, including the focus on homicide, some tricky stuff about accomplice liability, being aware of the specific intent associated with the specific intent crimes. You want to make sure that you can distinguish conspiracy, attempt, the completed crime, the relevance of mistakes of law, mistakes of fact, and so on. Yes? Okay. Yes. Yes, I mean, the question is whether that's going to be enough to help you tell the difference between answers when they show up. I mean, I think that's right, that if it is excused, what looks like the crime isn't a crime. Whereas justification, the crime is complete, but then there's this justification, right? So again, if you come across an answer or a question in your review that really requires you to make a fine-grained distinction between them, and it's not obvious how to do it, I'm certain, get in touch with me by email or whatever. But yeah, that's the distinction between them. Yes. Well, if what you mean is, can you reduce a crime from homicide to a lesser crime by offering a justification? Yes, because even, put another way, even the justification, well, a justification will reduce it to a variety of manslaughter. An excuse will make it not a crime at all. If your justification is not an excuse, that's right. If your justification is not an excuse, you're still criminally liable. If it's an excuse, there's no crime here, right? With self-defense, there's no crime here, right, for example. Whereas some of these other kinds of justification, right, there's still criminal liability. Okay. All right, so now with our remaining time, we will be turning our attention to criminal procedure, which is approximately 40% of the question. So it's not like it's an afterthought, and it really, from another point of view, can be thought of as enlarging the constitutional law portion of the MBE, because there's a lot of constitutional law in it, one way or another, however we want to understand it. Again, as I mentioned at the beginning, questions that involve criminal procedure are typically going to give you fact patterns that focus on events surrounding and immediately following the commission of the crime rather than preceding the commission of the crime, as we've seen in the substantive criminal law questions that we have been looking at. And equally important, we're going to be focusing on the behavior of law enforcement, or persons acting in the role of law enforcement, or persons who our defendant might believe are associated with law enforcement, rather than so much on the intent of the defendant themselves. All right, so those are kind of general guidelines that we want to be aware of. So, for Miranda Warning type questions, it's crucial to keep in mind that Miranda is triggered by custodial interrogation and not before. So failure to Mirandize is irrelevant if there is not yet a custodial interrogation, and various other rights are triggered by being in custody that are not relevant until the defendant is in custody. So that is often a question, right? Was the defendant in custody may direct us towards the right answer to a particular question. All right, so question 13. Okay, and it will be probably, if we imagine this being rewritten, it would be his confession, right? Because it is more or less a confession. Right? So this is going to be, is it coerced? Is it uncoerced? Did Miranda apply, etc.? So from the top. All right, so is the statement admissible? So this kind of, it's a little bit like an evidence question, it's a little bit of a con law question, it's a little bit of a crim pro question. Is this statement admissible? Yes? Okay, and so what are our yes answers? Right, if those are our only choices, this is a really easy question. So let's look at our wrong answers and then also talk a little bit about harder right answers to distinguish. Okay. Right, neither of which would render it inadmissible. Those would go to weight, not to admissibility, right? If he had said, if all he had said was, you know, I don't know, is there a statement we can come up with that we think would be more ambiguous about whether he did it? How about she deserved it? She had it coming. I'm glad she's dead. Right. These are statements which would be just as admissible even if they were not, he could say, I found her like this, etc. Okay? And the last one? Right. So that, I think, is only likely to mislead you if you're not training your own instincts, right? If you're training your own instincts, you'd never read it, right? So you'd never think, is he in custody? Isn't he in custody? This is made very easy, right? He's in his own living room, right? He is not in custody. Right? That's not a close call custodially. Right? You may see some closer calls, but hopefully they will also have answers that are easy to distinguish. Right? So free to leave, right, is the usual standard. Is someone in custody? Do they feel they're free to leave? Right? Right. They don't feel free to leave, then it may be custodial. Right, so that's really the test, is free to leave. Do you feel that you're free to leave? All right. Our next subject has to do with who has standing to contest the admissibility of evidence. So it's a little evidence, a little con law, a little crim pro, similarly, right? So there are warrantless searches that happen. We'll need to learn the test for the warrantless search, but you also want to be paying attention in these questions to against whom the evidence is sought to be used, right? Who has standing to contest the search, right? Because evidence that cannot be used against one defendant may be able to be used against another defendant, and that you're going to see frequently, right? Evidence found in the house, the car, the locker of X that may not be able to be used against X, but could still potentially be used against Y, as the case may be. Okay? So that's our question 14. So this is kind of evidence, kind of crim pro, right? Is the evidence admissible? Is the evidence not admissible? Right? Let's take it from the top. Right. So our defendant is seeking to suppress the evidence, not Morgan, the person in whose car it was found. Right? So is this evidence admissible against our defendant? His motion is to prevent its introduction. Does he have standing to move to prevent the introduction of this evidence?
No, because it was
Right, and so his motion will be denied. Right? Which of our answers gets us there? Right, because he has no reasonable expectation of privacy in Morgan's car. Right, Morgan does, right? And so this is a warrantless search with respect to the heroin, right? Because Morgan was only stopped for speeding, right? But again, we're not asked all the details of that, right? This is just, don't be distracted, right, by the fact that it's defendant and not Morgan, right, who is seeking to prevent the introduction of the evidence.
the main issue here is standing. He has no standing.
Right, he can't contest it, right?
But Morgan,
Could have and would succeed if this evidence were being offered to convict him of possession. It was a warrantless search, right? So when are warrantless searches okay? That's on page 121. So you want to know whether whatever kind of mnemonic you want to use, we want to make sure that you substantively have the warrantless search exceptions. So what are they? Well, when they're searching a car, right, if they have probable cause to search the car, that probable cause extends even to concealed places in the car, right? But not every time they stop you for speeding means they've got probable cause to search the car.
but they're not if they take the defendant back to police.
That's different. But we should start at the most general level, right, for warrantless searches. So the first of those is incident to lawful arrest. All right, so the search incident to lawful arrest requires there's no additional warrant for the search. The search incident to lawful arrest can happen without any warrant. The stop and frisk, so long as based on reasonable suspicion. That's a search of the person. If there is consent, so consent obviates the need for the warrant. That makes the search voluntary. Well, there's the car, but this is the search of you. What are you consenting to the search of? But whatever you consent to the search of, they can search. But your consent to a search of your person is not consent to the search of the car. Correct. Hot pursuit, also known as exigent circumstances. Evanescent evidence. It is evidence that is likely to disappear if you have to wait to get the warrant. Yeah, that's the plain view exception, which is different. Evanescent evidence is evidence that itself will go away, right? Like the blood alcohol level, right? Various things that are about the condition of a body or condition of premises. They can do the search while the evidence exists and don't have to go get a warrant for something that's about to be destroyed in a fire or whatever. And the plain view, so-called plain view exception, and that requires plain view from a place where the police already have a right to be. So if it's in plain view from outside the house, they may be able to go in and get it. But if they can't even see it until they have come in without a warrant, then that does not count as plain view. So plain view if it's on the passenger seat of the car when they stop you for speeding, right? But not plain view if they have to already have opened up the trunk in order to see the hidden compartment. Because if they don't have a right to be there, then that's not plain view. So the plain view exception is plain view from a place that law enforcement already has a right to be. So familiarize yourself with these. It's not so important how you enumerate them exactly, right, as that you're familiar with these circumstances that will give you the exceptions. Okay. The way they're enumerated in my materials is incident to lawful arrest, stop and frisk, consent, hot pursuit, evanescent evidence, plain view, and then throughout the car provided there's probable cause. Okay. Right. There's no probable cause. Probable cause for her. No, that's not probable because it's not particularized to her. That's not probable cause for her. There's more protection for the person, right, than that, right? That is, they can't do a body cavity search of you because you're seen leaving a place where there's reason to believe some people have bought drugs. If they have no reason to believe you bought drugs, they can't be doing body cavity searches standing outside the door of the bodega of every single person who goes in and comes out, even if they might be able to search the place.
So they can't generalize that every person that's coming out
Right.
is
Not for a search of the person. Right. Okay. All right, page 122A and B is going to take us through the last of it and then our last question in this area. So, at the top of page 122A, some commonly tested questions, although we don't have a question that is about just this, so just things to be aware of. The right to trial by jury and the right to confront witnesses. So the right to trial by jury only applies to serious offenses with a possibility of imprisonment of 6 months or longer. And the right to confront witnesses has its exceptions. So there is a general right to confront witnesses against you, but there are some public policy reasons that have been carved out, including the child, witness, or victim. And I think you're unlikely to encounter too many other sorts of witnesses that you aren't allowed to confront. The confrontation clause is important, right? It's an important protection of the criminal defendant's rights, and so you don't want to generalize too readily from the fact that there exist exceptions to the right to confront witnesses to think that it's really a balancing. It's not really a balancing. You have a right to confront witnesses, and then there's a narrow exception to it. So you want to be aware of that exception without kind of running away with itself. To prevent, under what circumstances? Yes. 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 And then there's a note here, and this is important, and we want to fill in this our little chart here about the scope of the right to counsel. And of course, you always want to be reminding yourself that only the criminal defendant has any right to counsel at all, for better or worse. That is how it is. Only the criminal defendant has a right to counsel. And even the criminal defendant's right to counsel is limited. Right? The clear black and white rule is at trial. Right? So there's always a right to counsel at trial, and no aspect of the trial at which that right does not attach. But pre-trial and post-trial, it's a little bit more complicated. So there's a pre-trial right to counsel during interrogation, during arraignment, any post-charge lineup, and at hearings involving probable cause. Those are the big ones, pre-trial, interrogation, arraignment, post-charge lineup, and hearings regarding probable cause. And then coordinately, there is no right to counsel for any pre-charge lineup, during a photo ID, right? So while a victim is looking through a book of pictures, none of the people pictured there have a right to counsel yet, nor during the taking of either blood or handwriting samples. Again, typically that's pre-charging, but those are not events to which one is entitled to counsel. Similarly, post-trial, there is some limited right to counsel. So there's a right to counsel during the entry of a guilty plea, during sentencing, and for any appeal as of right. So that criminal right to counsel continues through kind of to the natural end of that criminal proceeding. So for the guilty plea, for sentencing, and for any appeal as of right. There's no right to counsel for discretionary appeals, parole or probation hearings, or other post-sentencing matters other than the sentence itself. Yes. Yeah. Yeah. So our last practice question here is number 15. Okay, so that's what we're going to want to pay attention to. Fingerprinting and taking of a photograph. Now, in light of what we just did, do you have a right to counsel at that stage? Fingerprinting and taking of a picture. Well, we don't know if he's been charged yet or not, right? Right. So, well, but it didn't happen at trial. His objection at trial is going to be about pre-trial events where he's going to claim he had a right to counsel and didn't have it. So the question will be whether these things happened before or after he was charged. Yes, but not necessarily post-charging. Those aren't the same things. Being arrested is not the same thing. But but not for everything they may then do to you. Yes, you have a right to request counsel if they're going to interrogate you, but you don't have a right to counsel in a pre-charging lineup for purposes of a photo ID or during the taking of blood or handwriting samples. You don't have a right to have that act be counseled, right? Even though they can't question you outside the presence of your attorney if you have requested one. And taking your picture, sure, because the time for your attorney to object will be later. Yeah. Okay? So, right. And so, his objection is sustained or overruled. So we'll look at our